Well, hello and welcome to episode 2 of the Warlows YouTube legal channel. My name is Samuel Woff. I'm a commercial construction lawyer, construction litigation specialist, and partner here at Warlows Legal. Today I'm joined once again by Harriet Warlow-Shill, partner at Warlows Legal as well.
Yes, hello Sam and welcome. You have joined us as a partner since our last podcast, and it is really exciting to be able to build Warlows Legal and to have such amazing talent on board, and we look forward to assisting our construction clients and our litigation clients even more than before. So it's so good to have you. Thank you for joining.
Oh, thank you, Harry. It's my pleasure to be on board, and I'm really excited with the direction that the firm's going to take and the work that we're able to do for our clients over the coming months and years. It's a really exciting time to be here.
Yeah, it's great.
And what we're going to be talking about today, it's a good segue actually, because we're talking about something that is going to impact our construction clients very, very intimately, particularly the ones who are involved in domestic building disputes. And just to provide a bit of a lay of the land for people that might not be aware, in Victoria, the arrangement is that if you have what is termed a domestic building dispute, then the principal place that you go to have that resolved, although not the exclusive place as we'll see, but the principal place is intended to be VCAT, the Victorian Civil and Administrative Tribunal. And that was really set up to reflect the fact that building disputes, at least 20 years ago, when the process was initiated, were intended to be, or expected to be relatively minor, relatively straightforward and appropriate for the sort of more informal nature of VCAT. One of the challenges that we've seen, which has really kicked off our discussion last time as well as will be the subject for today, is that in a lot of ways the domestic building scene has outgrown the apparatus that VCAT was set up with 20 years ago, and is really starting to chafe at the edges, and that has been a challenge for the tribunal in recent months in particular, and something that's for practitioners in the field has really attracted a lot of our attention. And so that's really kind of was the premise of our discussion last time, and we have an update for our audience today.
Yeah, so what kicked off a whole lot of chaos, aside from some of the structural issues that were already underlying from COVID, and as you say, the growing sophistication of construction disputes. So on top of those layers of cake, so to speak, was sort of the killer layer, and that was the decision in Thurin and Krongold, which came out almost a year ago to the day. And since that Thurin decision, as we described in our last episode, there's been a cascading amount of complex decisions coming out of VCAT, defining what is it that VCAT can make decisions about and what it can't, because it's a tribunal, not a court. So because it's a tribunal, there were decisions saying that it didn't have a limitations period, which means that instead of the usual, say, 6 years to bring a case on average, you could have brought a case from 30 years ago. But on the other hand, you couldn't bring a case for contributory negligence under the Wrongs Act. So for example, say you're a builder and you're defending an action from a homeowner, and maybe someone else contributed to the defects in that building. You couldn't join anyone. So that meant that VCAT became a mess of confusion, and that's where it's been for the last year. And it's been extremely challenging for anyone, practitioners and members and participants in litigation. So then the Court of Appeal actually had an opportunity to clarify a lot of these issues, because Thurin and Krongold had some aspects of the Supreme Court decision appealed. And so that came down, a couple of weeks ago, Sam?
Yeah, I think that's right. It's relatively hot off the press. So we're still kind of unpacking it and what it means, and obviously there'll be further judicial consideration of that decision going forward. But I think that there are a couple of kind of key takeaways from that decision that we can probably try and sort of articulate to the audience. Now, I mean, for me, one of the big things was, so with the issues that were confronting VCAT, one escape valve that they had open to them was if they get into an issue where they find that they have no jurisdiction to hear a particular matter. One of the things Krongold Round 1 talked about was the ability to refer a matter out to a court in the event that VCAT finds themselves sort of hamstrung by a lack of jurisdiction. And so this section, it's section 77 of the VCAT Act, sat there in the VCAT Act for a long time, kind of unused. It was a tool in the toolbox that just never really got taken out and implemented. And so when it became apparent that that was an option and that was an escape valve, suddenly people actually pulled that section out and started looking at it and realised that there are some ambiguities in there,
Yes.
as in with many drafting. And so they went to actually apply the section and found that, well, actually there's a little bit of uncertainty about how this operates. And one of the things that was uncertain about it was if you are going to refer a matter out of VCAT to a court, the question arises as to whether that referral operates to continue the existing matter, it's just sort of a change of venue, or whether it requires the existing matter to be stopped and a new matter to be instigated in a court. And in one sense, that doesn't seem to make a big difference, but it does in one important way, which is that if you just continue a matter, then there's no questions of a limitation period applying. Whereas if you cease a matter and then restart a new matter, you have to restart that new matter within the limitation period provided by the statute. And if the case has been knocking around VCAT for years and years and years, it's quite likely that if you went to the Supreme Court to start a new action, that you'd be time barred because you would have been outside the 10-year limitation period. And that's exactly the issue that the Court of Appeal had to deal with in Krongold round 2, if we can put it that way. But fortunately, there was a happy ending in relation to that. I think we can describe it as.
Well, happy depending on if you're Thurin or Krongold.
Yeah, well, that's true. Or if you're looking at it from a administration of justice overall perspective.
Yeah. So the court held that the limitation period isn't basically a referral from VCAT to a court doesn't affect a limitation period. It's a continuation of a matter.
Yep.
However, there's a catch.
There's a nuance to watch out for, like all good decisions.
And that nuance is if you have sought to improperly join a third party, and we'll get to how that works soon, then referral out to a court doesn't cure that. So if you want to elaborate on that.
Yeah, well, essentially, I mean, one of the mechanisms available to VCAT, consistent with what is available in the courts, is, as you alluded to, if you are a defendant and you say, well, I accept, or maybe I don't accept, but if the court finds or the VCAT finds me to be partially responsible for somebody else's loss, there's also a third party or a fourth party or a fifth or 15th, 16th party, as is sometimes the case. There's also somebody else who is also responsible for the plaintiff's loss. And so what I want to do is I want to join them into the proceedings so that their claim as against the plaintiff can be considered at the same time. And the VCAT has the power to do that. Well, sorry, courts have the power to do that. And it was thought until recently that VCAT also had the power to do that. But as a consequence of recent judicial decisions, it was found that the power to do that only applies to something which is a court. Only a court can join a third party. And VCAT being a state tribunal, it was held is not a court, and therefore 20 years of practice of joining third parties to proceedings really were done without a legislative basis. And so once that became apparent, the Victorian Parliament, to its credit, has introduced a draft bill to fix that sort of anomaly, because it is just really a drafting anomaly rather than sort of a deliberate oversight. But the consequence for matters that are referred from VCAT to the Supreme Court or to another court under Section 77, what that means is that if a party was joined by VCAT pursuant to a legislative power that it didn't have, the fact that you refer the matter out to a Supreme Court or a county court or a magistrate's court, which does have the power to join a third party, that doesn't cure the original defective jointer of the third party. So the referral power does not sort of just make good the fact that VCAT didn't have the power to order the contribution in the first place. What that means is that whilst the limitation period is not going to apply as between the plaintiff and the defendant, the plaintiff is not initiating a new action. If the defendant subsequently wants to rejoin the third parties that they originally had before them in the VCAT case, they will have to instigate new proceedings against those third parties, and that is particularly the instance where the limitation period might have applicability to bar those claims. Now, the legislative changes that the Victorian Parliament are proposing does include a provision where a court receiving a referral from VCAT has the power to extend a limitation period if it considers, I think, the circumstances just to do so. So that does give them some latitude potentially to extend the limitation period in relation to the joinder of third parties. But we're just going to have to see how that plays out in practice. And certainly, if you are a defendant or you're acting for a defendant, that's something to be alive to, that the referral is not a magic pill, it's not a placebo that just suddenly puts everything that was at VCAT and regularizes it by putting it before the Supreme Court. You need to think through those contribution issues, because that's certainly something the court addressed with.
And also, so for the case of Thurin and Krongold, Krongold Construction couldn't join the other parties that they thought may be jointly liable for some defective works that were allegedly undertaken at the Thurin's domestic home building site. So that meant that although the matter's been referred to the Supreme Court and the limitation period has not expired, through that, as a result of that referral, there's been no interruption, so to speak, there's not been a new matter, it's a continuation. But the problem is that because Krongold never had the power in the first place to join the third parties, because we've now discovered that VCAT never had that power, that means that Krongold has to join those third parties. So because it's been over 6 years, they're now out of time. So that's a real problem. I guess that Krongold's lawyers are probably thinking about as we talk.
I'm sure they're coming up with some,
they're very competent, and I'm sure they are.
But I mean, it really just highlights the bigger issue, which is that we need to get these sorts of mechanical issues right, because otherwise far too much of lawyers' attention, so our attention, and the system as a whole, far too much of that attention is focused on just figuring out the mechanics of how all of this is supposed to work, rather than focusing on what is the most important thing, which is resolving disputes between clients in a just and fair way. And that's really needs to be the name of the game, particularly in light of, well, especially with VCAT, but it's a perennial issue in light of the crippling delays that the court system is going through. If you can get these sort of back-end things right, the process things right, it frees up judicial thinking time to just quickly, efficiently, accurately and fairly dispense with the disputes that are in front of them, rather than our attention being pulled away on these peripheral issues. Now, that's not to denigrate the importance of getting these issues right, but rather to highlight the fact that this isn't just boring mechanical, administrative stuff. This actually has a real impact on the operation of the justice system as a whole. And especially because hopefully everyone lives in a home, and these are legal issues that affect everyone, whether you're renting or not. You're still living somewhere, and if there are building defects, they need to be resolved. Absolutely. Now, the as you mentioned, there is legislation now to sort of cure a lot of the ills. As I understand it, as you say, the courts can allow the inclusion of third parties when this bill is passed. I don't believe it's passed yet. No, I don't think so. I think it's we'll have to do another episode when it actually comes through. Lucky you. However, it does mean that effectively we look like we're now heading towards, we've had a year or more now of really unsettled law with regard to where to start proceedings and how to start them. It looks like we're coming to the end of that. And I have also noticed, Sam, that there's been a lot of discussion about greater funding for VCAT, and I think that we should all definitely support that. I think that we've got a new premier now, and I suppose if I could ask one thing of our new premier, it would be to provide more funding for VCAT so that we can really get a lot more access to justice for every Victorian. Absolutely, because I mean the reality, whilst the Court of Appeal and the Supreme Court hear the most important and arguably from, say, the media's perspective, the most glamorous disputes, the reality for most people that intersect with the justice system is that they're going to intersect with it through VCAT. Statistically, most disputes in Victoria are resolved through the Victorian Civil and Administrative Tribunal, so it's really the front page for how people are going to assess how the justice system is operating, and if it's working fairly, if if it's working consistently, it's working quickly, then they're going to walk away from it, really win or lose. They're going to walk away from it feeling like, well, at least I had a fair go and I feel like justice was done. Conversely, if there are delays, if there's confusion, if there's unnecessary expense spent in trying to resolve these sorts of mechanical issues, then they're going to walk away with an overall negative impression. And that's not only bad from a, VCAT will get bad reviews on Yelp, and that obviously is part of the problem, but more fundamentally, people will lose faith in the operation of the law.
Yeah.
And we're very, very fortunate in Australia that that's, generally speaking, not an issue, but we shouldn't take that for granted. And that gradual erosion of faith in how the law is going to operate is a real issue, and so we need to get it right. And so more funding, plus hopefully some legislative intervention, as well as clarity from the courts. Those three pillars are really hopefully going to move us in a direction where VCAT starts operating at a much higher level of functioning than it currently is.
So thank you for joining us, and thank you, Sam, for raising that really important issue and setting it out for everyone. And if you have any questions, just be in touch. We're happy to answer any queries and see wherever we can help at Warlows Legal. So thanks for joining.
Thanks for joining, everybody. We'll catch you next time. And just a reminder, obviously, that this information is for informational purposes only.
Yes.
Doesn't constitute legal advice. As Harriet said, please get in touch if you need specific legal advice for your particular circumstances.